Slide, please. Hello, everyone. This is Gail Pendleton. I'm Executive Director of ASISTA Immigration Assistance. Also with me today from ASISTA are Cecilia Friedman-Levin, our Senior Policy Counsel, and Maria Lavarino. Maria, what is your title these days?
Program Associate.
Program Associate, right. Okay. So this webinar is slightly more advanced than some of the previous ones we've done for grantees. It is in a format that we particularly like to do to encourage more interaction between us and you. So we're covering some of the issues where we often get a lot of technical assistance questions, and there may be a bunch of different ways that you have to address the issues that we're raising. So we're going to be doing polling and raising hypotheticals, but perhaps not getting into as deep a dive into the law and more practice in how to frame arguments. And similarly, our final webinar in this series, which will take place on Monday, May 8th, the same time, 2 to 3:30 East Coast time, will be how to respond to RFEs, and both kind of the best practice in generally how to put together evidence and frame your arguments, but also targeting some of the hot issues that you all would be seeing in the RFEs that you are dealing with and how we are helping you respond to those. So the goals of this particular webinar are that at the end of this session, you will be better able to troubleshoot derivative issues, strategize on difficult inadmissibility issues, determine when and why and how you're going to file for extensions of U visas for principals or derivatives, and ponder and decide whether and how to include new derivatives that weren't included at the U stage at the adjustment of status phase for your principal U visa applicants. Okay, next slide, please. Turn it over to you, Maria, for an overview of derivatives.
Thank you, Gail. During the prior webinar, as I was saying, we talked about derivatives in the U visa and in the I-929 context. During the webinar, we will have different cases, scenarios, and polls so we can apply everything we learned until now. The next slide, in particular, will talk about derivatives of U visa applicants. So one more time, in the U visa context, is the principal applicant, the U1, is under 21 years.
Maria, we're having trouble hearing you, so I don't know if it's holding the phone closer to your mouth.
Okay, what about now? Okay.
Oh.
Is the principal, now it's better?
Just a little bit. It's still kind of in and out for some reason.
I can talk a little louder if you want.
Okay.
If the in the U visa context, if the principal applicant, the U1, is under 21 years, derivatives can be the spouse, children under 21 years old and unmarried, parents and unmarried siblings under 18. If a principal applicant is more than 21 years, then derivatives can be spouse and minor children. Remember, minor children are unmarried and under 21 years. So let's review the case scenario.
Okay, so I know that was a little hard to hear, and so am I easier to hear now, Cecilia and Patricia? I'm holding the phone as close to my mouth as I can. So
it sounds great.
Okay.
Yeah,
so I'm going to pose a couple hypotheticals. I think we're going to start posting the polls, right? So we're going to get your feedback and then have a little discussion. So here is the first hypothetical. Sebastian is the principal 13-year-old U visa applicant. He has a 19-year-old sister, Gloria. Can Gloria be a derivative of his application? So
okay, we have...
Give people a chance to vote a little bit here.
Yeah.
So again, the principal is 13 years old, and he has a sister who's 19, and she filed as a derivative. Okay, shall we start answering the question now? Still going back and forth. People seem kind of divided. More people are saying no than yes. So,
yeah, no, close. They are changing. Give them a second to close the poll game. Okay, now it's closed for voting.
So Maria, what's the answer?
Wow. The answer is no. Gloria cannot be a derivative because she's more than 18 years old. She cannot be a derivative sibling on Sebastian's application.
Okay.
So,
and this is because in the actual statute, it says that the siblings have to be 18 years or younger, or up to 18 years or something. So it's different. For those of you familiar with the child definition in the immigration law, it's not tied to that.
All right, let's go to the next one.
Okay, this is going to throw this out for you. Can we go to the next slide? It's in the chat box, so you all are seeing it. I'll read it from the chat box. Oh, here we are. Sebastian's mom, Angela, has also been helping law enforcement in the case. So, Cecilia, would this potentially help out Gloria? And
let's see what people say.
Yeah, let's see what they say. Because we've decided Gloria can't file now because she's over 18, as her brothers.
Right. All right, we'll just give people 20 more seconds. All right. Let's see if we can close it. All right. And the answer is, well, I really like kind of the lawyer answers of the 23% of you who said it depends. I think that, I don't know, I find it funny. So the answer is kind of yes, and it depends. So I think that if Angela could show that she could potentially be an indirect victim and could meet the qualifications for harm and for helpfulness, that we could potentially have Gloria, who's 19, included as a derivative of mom's application. Because remember, to be a minor child is under 21. So while she might not be eligible as a derivative under her brother's application, she could potentially be a derivative if mom qualifies as a principal victim for a U visa.
We've seen a lot of indirect victim moms for child survivors of sexual abuse, right?
Right, and I think this happens a lot in cases where the primary victim is maybe a minor U.S. citizen, but it doesn't necessarily have to be. But if mom can be framed as the principal applicant, then that would potentially help out Gloria.
It might be complicated if they were both principal applicants. So this would be an example that if you have a case like this, you might want to contact us for individual technical assistance to sort out the best filing plan.
Mm-hmm.
Okay, shall we do the next typo then?
Sure.
So Sally is a U visa applicant on the wait list. She has a 20-year-old daughter, Sophia, who is a derivative. Now Sophia wants to get married. Will this affect her application? And then we'll get to what are you going to tell your client once you decide that.
Wow, we have 100%. I agree.
Okay, so I guess we can move right along here.
Yeah.
So far everyone thinks it will affect their application. Maria. Why are they correct?
Children must remain unmarried until the adjudication of the U visa application. And this is very important because after a few years that they are on the wait list, they forget about that and they go and get married. So please advise in writing to your clients to remind the kids to remain unmarried. Sophia can date, she can have a boyfriend, but she cannot get married. Thank you. That was nice.
Right. Yes, right. And this is because for those of you who are aware that in VAWA 2013, Congress did add a provision to make sure that children didn't age out so that Sophia can turn 21 And as long as her mom filed before she turns 21, she's okay. But she still can't get married. That would take her out of that quote-unquote child category.
Right, and again, and this becomes, I think, just one more note on this. This becomes more and more important as the wait list gets longer and longer. Yeah. And so I think that it is complicated, but again, until a person has a full 4-year visa in hand, Sophia's going to if Sophia gets married before then, it's going to cause a problem. So I think it's just very important to make sure that as an applicant and on the wait list, that this could be an issue. And that's all I'll say.
And so it seems like, as you say, maybe this needs to be one of those things you tell your clients at the beginning, because you may have filed and they go off and live their lives, and then Sophia shows up and says, oh, here's my new husband, and so what do you do now? So,
right.
Which is also what we're here for, because that happens a lot.
It happens
okay, I think we have one more hypo.
Yep.
That one. So now Sophia has decided not to get married while she's on the wait list, but once she gets her U3 status, she reconnects with her potential partner and gets married. Will that now affect her status?
All right.
A well-educated audience there. All right, consider this the warm-up portion of the webinar. I don't seem to know the answers.
Right. And we designed this, I mean, we want you to be as engaged as possible in this format. So we want to avoid the checking of the email or of the Facebook, as my mom calls it, and we want to really make sure that we can make this as interactive as possible. All right.
Okay, so want to take it, Cecilia?
So I kind of hinted at the answer when we were talking about the last hypo. And I think that this is kind of a complicated issue, or not really. What they've said is, what USCIS has said on this is that once people get that full 4-year visa, that magical day when you get your actual U visa, that the marriage of U3s typically would not affect the derivative status. What they've said is that this is all case by case, but generally they're not going to be in the business of revoking status because of marriage of a U3. This also comes up, I think, in cases where maybe the U visa principal wants to get divorced from a U2 derivative. And in those cases, it can be a little bit more complicated, especially if the separation or divorce is due to domestic violence. And I think in those situations that there is potentially more of a likelihood of revocation if there is a divorce that is kind of related to domestic violence. But generally, if we're talking about kids getting married, once someone has a full 4-year visa, we are not seeing that affecting the status moving forward.
Okay, so let's put up the slide that's a summary of the U derivative. See if anybody has any questions on derivatives before we move on to the inadmissibility section. Maria, you want to summarize this for us?
Yes. Let's review what the ACFR 214.4 talks about the relationship. And it says that the relationship between the U1, the principal alien, and the qualifying family member, which is the derivative, must exist at the time the petition is filed, continue to exist when the petition is adjudicated, and continue to exist at the subsequent admission to the United States. With exception
yeah, but Maria, this just to be clear, this regulation was written before the statute was fixed. So the law right now is only that the relationship has to exist at the time it's filed. The second two prongs are fixed.
I also want to say that there is also an exception if the parent, the U1 principal alien, proves that he or she has the parent of a child after the I-918 was filed. And this is also important because we have sometimes clients, principal U1 that are residing abroad, and they get pregnant, and they don't tell the client until it's a little late. So It's important to communicate with your client if you have clients residing abroad, that it's okay if they get pregnant to let you know so you can plan the logistics ahead of time. You can send all the forms to the client, get the form signed back, and when the baby is born, get a scanned copy of the birth certificate, and you complete the missing information on the I-918A, date of birth, name of child, and you can mail the I-918 package to the Vermont Service Center without waiting until the baby is born and all that. That will delay the case. And also, what Gail was saying is about the definition of the INA, which is a child that is an unmarried person under 21 years of age who is a child born in wedlock and a stepchild and a child legitimate under the law. That must be 28 at the time of the derivative petition is filed, adjudicated, and approved. And thanks to VAWA 2013, which added a specific age of protection, this is fixed. And it says that the age of the qualifying family member, the derivative, is established upon the day of which the principal, the U1, properly filed for his or her non-immigrant status in the form I-918. This also applies for derivative siblings under 18 that are unmarried and they grow up and they became more than 18 for the wait list of the U visa. And with the 2013 H.O. does not address marriage. This is what Cecilia was explaining in the prior slide. So there are no regulations about what happened with derivatives when they obtain the 4 years U visa approval. What happened with them if they get married. We encourage them to remain unmarried if possible until they apply for the adjustment of status.
So this is an example of where the regulations are old, which is true for the regulations generally. They have not updated the U visa regulations, and the statute's been changed several times since then. We think that all of the adjudicators are trained on what the law says, but you may sometimes get RFEs, requests for evidence, back from Vermont or Nebraska, citing things in the regulations that have actually been changed by the law. And when that happens, you need to let us know, because one of our jobs is we contact the heads of the unit and the people at headquarters and let them know there's a training issue. So I'm not seeing any more questions on derivatives. For those of you who don't know, you would put that in the chat box. You can still ask them, but why don't we move on to the inadmissibility section?
Yes.
Okay, so I think we're going to start with identifying immigration violations that might pose inadmissibility problems, right, Maria?
Yes, and what are the things, what are we screening for when we are preparing a U visa package? What we want to know about inadmissibility issues. And please use the chat to type some of the questions that you may want to ask your client if you want to identify some encounters at the border. And we will review the question. In the meantime, I want to say just a few tips. Be always respectful with your clients and polite. And when interviewing a survivor, explain the type of question that you will be asking and why. And if you can, bring your domestic violence, sexual assault advocate to the very first meeting. And remember to ask your client if he or she needs an interpreter during the meeting. I don't see anyone typing.
Right, and I think what we're looking for here is because there's kind of this, a lot of potential things that could happen when people are entering the country. And so, for example, if they had some kind of interaction with an immigration official at the border, and people could say, okay, like I talked to somebody and then I went back. And so what could that potentially mean? And what kind of questions do you ask to get at what that means? So, for example, some people ask, did they take your picture? Did they take your fingerprints? So how do you figure out, and what are the types of things that you can kind of ask to figure out what it is that happened? And when we're talking about those things, and what are you screening for, this is kind of the menu of options. When you're talking about immigration violations and inadmissibility grounds related to immigration violations, what does that mean? What are the types of things we're looking for? And kind of listed in this this bulleted slide are the types of things that we're kind of citing as potential grounds of inadmissibility. So if you don't know, also, you can type in the chat box, what are the types of things that you could do to find out what happened at the border about the entries and exits?
For example, we can ask, have you ever been stopped at the border when you were trying to enter to the country? And what happened there? Were you fingerprinted? Did you sign any paper? Did the officer send you back to your home country? What happened there? So please type in there some examples that you use to screen your clients.
Right, or what you would do to find out.
Yep. So people is typing.
I think they're working on it.
Yep.
So I'll read you what people are saying. Ashley says, have you ever talked with an immigration officer? Did you sign anything? How would you, so here's something I would even suggest is describe what an immigration officer looks like, right?
Yes. Have you ever been stopped by someone using a blue uniform?
Did they show fake documents? That's a very good question. You may need to explain what fake means.
Yes. Yes.
Right, submitting FOIAs to CBP, to ICE, to EIR, and the other option is the OBIM FOIAs. I don't know if people are familiar with those, which is the Office of Biometric Identity Management. Is another way that you can kind of ascertain what happens at the border.
And I was thinking also, I'm sorry, sometimes clients get confused when they get paper about an NTA or a permit to entry to the country. So that's a good question. Did the officer, do you think you got a permit to enter to the country? Because we have some cases when say, oh, they gave me a paper, they gave me a permit, and it was an NTA. So ask for the question, did you get a permit to enter to the country or any paper?
Right. And so a couple other suggestions are, have you been in court? And again, you may need to describe it because immigration courts don't necessarily look like what people might think federal courtrooms look like. Maria, what was it you wanted to have repeated again? The FBI OBIM information? You can send that out. That's something that came up a lot in the training we were doing on the West Coast.
Yeah, and I can put in the chat box, the ILRC did a FOIA practice advisory, and I want to put that link in the chat box.
And I was thinking also, sometimes officers also say you cannot come back in 5 years. We have some clients that they know, the officer told me I cannot come back in 5 years. So ask those kind of questions. And as Cecilia is saying there, the FOIA is free. You can do a FOIA. It takes a few months, but the U visa takes way longer. So you have, if you are not sure about encounters at the border, do a FOIA. It will be good also for using later, maybe for the adjustment. And you can also always do an FBI, which is always more recommended for criminal record. But if your client was stopped at the border and fingerprinted, it will show up in the FBI records as well.
So can I make a couple general suggestions here before we move into the crimes, Cecilia?
Sure.
Okay.
Well, we have the high vote, but yes.
In general, while we're thinking you should do all of this, the main reason, let me put this, the main reason you want to get at this much detail is that it's really important that by the time you actually get the U visa approved, Citizenship and Immigration Services has specifically waived all the grounds of inadmissibility that you need waived. And so I am responsible, I take responsibility for this, for having in the beginning said everyone should include language that says any and all other grounds of inadmissibility that you find. The problem is that we're not seeing them understanding grounds of inadmissibility well enough to be able to tell from the facts in your application whether your client has triggered them. So, frankly, by the time they open up the case to actually do the U visa, which is going to be many years from now at this point, you want to make sure you have given them as specific a list of the grounds of inadmissibility as you can, including subsections. So, for instance, one of the typical immigration violations would be committing fraud by using a fake document. If it's regular immigration fraud, that's a different subsection of 212A 6B than false claim to citizenship. And we have seen consular officers say, no, Vermont didn't say which ground they waived, so now you have to get another waiver before we're going to give you the U visa to come back in the U.S. So this is the kind of thing we can help you work on, but if you're not intimately familiar with the grounds of inadmissibility and the citations for them in the statute, you really need to learn that, because that's going to be crucial to protecting your clients, especially if they travel.
Right, and that like little a at the end of the citation might make all the difference between you having to resubmit another 192. So being very kind of down to the detail is going to be important.
Right, and we can help you figure out if you're not a well-versed immigration practitioner, we can help you figure out from your facts what are likely. We would also, I think you can disagree with me, Cecilia, but we would not say you should hold off filing because of an immigration violation. We would just say that you want to have figured this out by the time we think they would open the case for a conditional grant, which is at least minimum 2 years from now, right?
Right, exactly. I mean, because I think the bottom line is that if it's not mentioned, it's not waived. And so that's why you really want to make sure through these FOIAs, through doing kind of, asking these questions, that you understand all the facts and you understand all the different issues that might be in play. And so I think that's really kind of what we want to make sure that we're doing, that issue spotting up front, so we can avoid problems down the road. Right. And I think why don't we go to the next typo and we can kind of talk about this in a little bit more detail in practice.
Yeah, I mean, the one thing you don't want to do is let your certification expire, basically.
No. Yeah, don't do that.
But I also have one more question. Remember to ask how they bring your kids, because it's very
how they what?
How their children.
How you bring your kids in the country.
Oh, bringing in the children. Yes.
The little kids use a birth certificate, U.S. birth certificate to come in the country, which you need to waive the USC claim. And maybe mom show the USC birth certificate for the child. So all those questions, ask them also for the kids. How did your kids came in the country? Or did you show something to allow your kids get in, Because
and so what Maria's saying is raising two kind of related issues that are related to an immigration violation. We are seeing, I don't know how we could fix the translation thing. I am speaking as close to my cell phone as possible right now. So we are seeing that Vermont issue on a regular basis requests for more evidence and requests for a smuggling waiver when parents have brought in children or others. And some of you may know that there may be a regular waiver available for that, but that is something to identify early on. And then the other issue, which I think is actually a more interesting legal issue, is whether a baby can commit a false claim to citizenship, frankly. I don't think they can, but the question is whether it can be imputed to mom, right? Okay, so that seems like that might be a good segue into the crime.
Yeah, let's do it. Next slide, please.
Oh, we're going to do a hypo first on this.
Okay, so I'll talk about it. Let's talk about Henry. Henry first entered the U.S. in 2006 without inspection, what we call EWI, enter without inspection, and then left in 2008. He came back again in 2009 and was picked up at the border. He was issued a notice to appear to go to immigration court, but didn't show up at his hearing. He left again in 2011 and then came back in 2014. So what do we think is at play here? And again, we can, I know that there's a lot of options, and I wish we should have thought of ways of just checkboxing them. But we can kind of talk a little bit about, so the options that we have is unlawful presence, a permanent bar, reentry after removal, entry without inspection. I think the citation is wrong for the, anyway. I have no idea what you're talking about. This is crazy. And there I noticed that there's issues of everything above and potentially others. But I think what this hypo goes to show, while folks are still kind of figuring out all the back and forth, is that things can get really complicated. And so that's why it's very important to kind of do the groundwork and laying out the different entry and exit issues. Shall we close it up? Okay. So what do we have here? Most folks said that, okay, let's break it down. Maybe we can go sentence by sentence. So let's go for the first one. He first entered the United States in 2006 without inspection, and then left in 2008. So here in that first sentence, Gail, what grounds of inadmissibility do you think we're working with, just in the first sentence?
Right, so you've got the EWI right there.
We have EWI, and then we have the triggering of
unlawful presence, the 212A9B unlawful presence bar.
So in that first
sentence, these are captioned incorrectly here.
Yeah, they are captioned.
Yes, 212A9B, for those of you who are confused by this, is the one where you accrue unlawful presence and then you just leave the United States. Right? So then, Cecilia, what does his 2009 reentry bring up for you?
Well, I think what's interesting to me about the reentry in, so what we have here is that there was an EWI, right, and then there was a triggering of unlawful presence, and then we have an entry after that triggering of unlawful presence. And so I think after that we have an issue with 212A9C. And so for someone who has been unlawful, or someone who is present, who has been in the past unlawfully present before for a period of more than 1 year. So that is what that shows to me, for at least in the next sentence. And then we have another issue with that other hearing, that you're issued an NTA but didn't show up at the hearing. So does that raise?
So he probably has what? What happens when he didn't show up?
So what happens within immigration court is if you have a hearing in immigration court and you don't show up, then what happens is that that proceeding goes on without you. And the judge typically enters in what's called an order, an in absentia order, or an order of removal against you without your presence. And so this is probably what happened to our friend Henry, is that if he had a hearing and didn't show up to the hearing, then it probably went on without him, and he has an in absentia order against him.
Now, is there anything you can do in the inadmissibility context to cure that? Is there any piece of that that's related?
I mean, I think it depends. It depends. So there are several criteria for motions to reopen in the in absentia context, and I think something that you would try to want to see is whether or not Henry had proper notice of that hearing, and to see whether or not kind of all of the different procedural grounds were complied with so that Henry could have had the opportunity to present himself. For example, did he have proper notice? And sometimes, after the fact, particularly if someone is U eligible, then Henry got himself into a little bit of trouble here. Henry made his life a little complicated. But in more simple cases where if you have just, for example, that you entered the United States and you were issued an NTA and would approach an ICE trial attorney to do maybe a joint motion to reopen if someone is granted use status, and that might be a way around getting the in absentia order.
Although one could also argue that he self-removed in 2011, right? So that's assuming he did never leave, because many of you will have these cases. And
Right.
you have an outstanding in absentia order. It's also one thing we've been pondering, and this is an example of an emerging issue that keeps coming up, is whether there are pieces of that you can cure in the inadmissibility grounds that talk about failure to attend a hearing. If you get that waived, to what degree could that help with overcoming an in absentia order? But it seems to me there's an argument that by self-reporting in 2011, that's basically closed that case. It may not close the inadmissibility problems. And what else does his reentry in 2014 raise that isn't even listed on this chart? Anyone know out there? So if people who are not, maybe we can close the poll. We can see if anyone's answering.
Yeah, the poll is closed.
Okay, well, I can't see the chat box. So the big issue that, for me, this is raising is reinstatement of removal.
Right.
Which is under 241A5. And if you're not familiar with it, you need to look it up, print it out, and have it next to your desk, because what can happen to people who are subject to reinstatement of removal, Julia?
They would be subject to expedited removal and removal from the country without a hearing.
Exactly. Yeah. And that happens. So, and especially if they encounter ICE, that can happen. So if you're not familiar with that, you can let us know. They have agreed that you can basically get it waived. And the Administrative Appeals Office has confirmed that you can get the underlying inadmissibility grounds that are part of reinstatement waived, but you have to do it or your client remains subject to reinstatement of removal. Okay, so now I think we can move on to the criminal history, Cecilia.
Right, and I think this all goes to show about that.
I'll answer the questions while you do that, okay?
Okay, sure. And so the criminal issues, I mean, again, just as we have to do a careful screening for immigration violations, we also need to do a criminal history check for criminal history to understand what issues that we're looking for that might affect the filing of a U visa. And when we're talking about like why is this important, the things that we're really kind of focusing on is kind of crimes of moral turpitude, aggravated felonies. We're looking for drug offenses and crimes of violence, or if there's any kind of open proceeding against the applicant. Because if there's ongoing criminal case at the time that you are filing, CIS is going to want to know what is going on with that and making sure that they have a kind of, I think it's fair to say, and if folks know otherwise, I think it's fair to say that they wouldn't necessarily have a final decision in your case if a criminal case isn't resolved in one way or the other. I haven't seen it. I think that sometimes it depends on the offense, but I think if there's kind of usually if there's an ongoing criminal case, they want to know what happens with that. So let's talk about that. Let's talk about inadmissibility issues. So while on the wait list, so with deferred action, it was the application has been reviewed, it's been placed on the wait list. Angela was arrested and convicted of possession with intent to distribute. What would you do about this? Would you file your 192 right away? You want to make sure that they know about it? Would you hold off a minute on filing? Would you not say anything? Would you wait for CIS to come back and say something to you? Or would you do something else? And if you would do something else, then we want you to write in the chat box what it is that you would do. Okay, there's 121 participants on this webinar, and right now we see about like 40 people. So we cannot see your answers. We will not judge you. but want to kind of see how you start thinking a little bit about what you would do if something came up in the course of this type of case. And it can be something else. So something else is you might do this on, would you do something that is kind of not in the immigration context? Would you try to do something in the criminal matter to try to resolve or mitigate this issue? Okay.
And actually, Patricia, I don't know if we can do this mid.
Yeah, why don't we end
it? It would actually be helpful to move the polls out of the chat so that we can continue, because I was in the middle of an answer.
Okay, yeah, so why don't we close this up? And so right now, 64% of you would say that you would file a 192 right away. And
work on rehabilitation.
Right, and what would you waive? What do you think that what grounds of inadmissibility would you waive? Multiple attendees are typing. I love it. Let's see what you got. Okay, Jessica has a plan. She's going to work on her rehabilitation, and then she said 212A2B, which is criminal grounds, and A2B is controlled substance, so it's the drug trafficking ground. And for that, it's important to know that a conviction isn't required, that have a reason to believe standard, which is different from other forms. Okay, so a lot of you would file it right away. 29% of you would wait to file, and I'm concerned about, what you would be waiting for. Maybe you would want someone to complete any kind of rehabilitation program or gain some equities. And I would not, the third option is wait for CIS to say something. And I want to talk a little bit for a second about all the different touches that CIS could potentially have on these applications. So we file, and then when we file and they're looking at the case to put it on the wait list, they will run the prints. Sometimes when they are going to review the case to take it off of the wait list and to issue the full 4-year visa, they are going to run the prints again. And chances are, if you haven't told them about something, by the second time they run the prints, they're going to say, what's up with this? Why didn't you tell us? And so by not disclosing, there's a potential for you raising credibility issues for your client, because it looks like you're kind of hiding the 8 ball. Is that the phrase? I don't know, hiding the ball. I don't know if there's the 8 ball involved. And then there's another touch at the time of the person's going to be ready to adjust. So you're going to have this case, they're going to have a case open for a while, right? It's going to be something that is kind of this constantly moving thing for a few years. And so I think by not saying something that you might potentially run into credibility issues. For the 2 of you, if you are brave enough to say that you would do something else, I'm really interested to know what you would do. But I think when you are framing inadmissibility issues, our friend Susan Boyer, who is at ICWIC in Oakland, has her 3 R's, right? It has taking responsibility for the action, that there is something to take responsibility for. It is showing remorse, that there's a recognition of what happened with inadmissibility issues, is that they are multiple, and then that they are kind of sorry for it. And the other thing, which Jessica is kind of onto, is the rehabilitation, and showing how this is never going to happen again, and that the person has turned his or her life around. So again, I think that we have to kind of be advising our clients that just because you're on the wait list, just because you have the U, that interactions with the criminal justice system may have potential ramifications.
And way I suggest you think about especially complicated cases with multiple convictions or serious convictions is how would you convince your neighbors who aren't lawyers at a barbecue you're at on why it was in the neighborhood's interest to have that person living in your neighborhood? Because I think people who are familiar with other kinds of waivers tend to equate public interest with like extreme hardship to the person. I don't think public interest is the same as the person's family interest or their own extreme hardship. I mean, I think those can be part of public interest, but you got to think about the harm to the community generally of that person continuing to remain.
Right, and I think that this is something that we're kind of, encouraging people to think about under the waiver, which is for U visas, which is under INA 212D14, and which is kind of that national and public interest standard. So I think you want to look at the fact of, how helpful was this person in the investigation and prosecution of the perpetrator of the crime? Is any kind of inadmissibility issue part and parcel to ongoing victimization? So we think you want to look at other types of cases in the VAWA context, in the T visa context, to kind of look at these other forms of arguments that are out there when you are looking to address difficult inadmissibility issues. And drugs are tough. It's something that they look at quite seriously. So I think
same with drinking, right? I guess they're both addiction problems.
Yeah, so I think that it's these are bigger deals, and I think kind of framing your argument.
That's why, Cecilia, some people may want to wait till they think it's closer to when they're going to actually open the file so that they can marshal more positive equities, right?
Yes, so I'm going to call that the Jessica approach. Work on her rehabilitation.
Yeah.
All right, and to see how it was resolved, exactly. So in Vienna said, you know what, you're going to have to, or, conversely, is there any post-conviction relief that can be done? Are there any kind of due process issues with the criminal proceeding that need to be resolved? And so I think that if we're going to do the something else category, looking if there's any post-conviction relief that might be available for Angela is another option. Okay, let's move on. All right, so we have our friend Veronica, who has a U visa, and the daughter who is abroad has an approved Step A, but the birth father in Mexico is not going to agree to a passport. What do you think you can do? The options are to try to resolve it through a family court, maybe have a custody proceeding and to give Veronica full custody, get help from the Department of Exterior, a Form 193 or on 192, so that is the waiver that you would get for failure to have a passport. Would you just have them kind of appear at Customs and Border Patrol? Or if you're like, you know what, I'm going to not vote, this has never happened to me, it's never going to happen, so I'm not going to worry about it. What do you think? And Maria, I think this is yours.
Say that again, Ceci? I cannot hear you now.
Okay.
Maybe we can ask how old is Veronica's daughter?
Let's say she's 10.
Okay, because sometimes it's easier, the kids turn 18 and they come in, they can request the passport without the father's consent, which happens many times. But she's 10.
So just to be clear, the main problem here is really more of a document processing problem than a legal problem, right? It's not like filing a 929 is going to solve the problem. She's still going to have a travel document, bottom line, right?
Mm-hmm.
Yep.
Right, and Jennifer says that, you know what, depending on the age, if you're closer to 18, it might not be an issue because you could potentially do a 929 or also just be able to obtain a passport on one's own and come in through the 918A, depending on how long she is in the process. So that's a really good point if she's older. Okay, shall we close it up?
Is that it for the hypos? Are we moving on to extensions?
I think we want to close this hypo up and see what people say.
Yeah, it's close. You have 65% resolved through family court in home country, 25% Form I-193, and 9% help from Department of Exterior of the country of origin.
Right, and so there is the DS. How many people know of the 232 document? Okay, well, so this is something that is available for people who do not have a passport. It's basically kind of an entry document, and so it has a passport requirement waived. And so the issue is the visa is issued on a form called the DS-232 in cases where the passport requirement has been waived. But generally speaking, trying to resolve the matter either with custody, I think, is what people most commonly do. And if this comes up in your cases, Sonia Perez-Conrad, who is also with ASUSTA, is a consular processing rock star and can help you walk through all your different options. All right, let's move on. Okay, can we close the poll, please? Thank you.
Yeah.
Okay.
That's my term. Do I extend or do I wait? We will talk about I-539 application. What are the circumstances for extension? Number one, when you are filing for an extension of status as a U1 based on law enforcement needs, because the aliens present in the United States is required to assist in the investigation or prosecution of criminal activity. You will file Form I-539 along with evidence. It could be a new I-918B or any other evidence from law enforcement. You also need to prove I-94 approval showing you non-immigrant status. The situation 2, exceptional circumstances, because, for example, you have a client that was under medical treatment. She was hospitalized for a long period of time and unable to proceed with the immigration case. You can also file an extension using Form I-539 and an affirmative statement from her explaining the reason why she couldn't apply for the adjustment of the status. You can also include medical records or any other credible evidence. And again, you need to include Form I-94 or approval letter showing that you already have been granted U.S. status. The situation 3, where you don't need to file for an extension, which is during the pendency of the application for adjustment of the status. You don't need to file the Form I-539. Once you file the AOS or the I-485 form, you will receive a notice from the Vermont Service Center saying that your non-immigrant status is extended. So nothing else to do in there.
Yeah, except we've seen them grant the adjustment, and then even after you've asked them to hold it. So we don't suggest that that's by itself going to preserve a child who hasn't gotten their status yet.
Okay, and number 4, the extension for derivatives beyond the expiration date of the principal, which means to file the I-539 after the U1 expire. You can do that if you can demonstrate that the delay was due to extraordinary circumstances beyond your control. For example, processing of derivatives alien U visa was delayed due to custody or passport issues, and that without extension, the derivative cannot comply with a 3-year requirement to apply for the green card under 245M. On the next slide, let me move my phone. We have an IPO. Yuri is a U2 visa holder who was only granted a 2-year visa when he consular processed in to join his wife. His U visa is about to expire. When to file, what to file. In this case, yep.
No, go ahead.
Okay, in this case, and because his U visa is about to expire, we will file right away, right when we have the package ready to go. Usually, in general, the Vermont Service Center requests that the I-539 are filed 6 months before the expiration date. What do we need to file along with the I-539? Always, in the U visa, we will file the I-539 at the Vermont Service Center. We will include Form T-28, Form I-539, filing fee. Actually, it's $370. Check on the day that you apply because it changed. You can also request fee waiver with a Form I-912 or with a letter proving evidence of income versus expenses. You don't need to pay biometric fee for the I-539 in the U visa context. So there is only the fee for the I-539. You need to attach birth certificate and translation, evidence of U status for both the principal and the derivative, copies of I-918 and I-918A approval letters. If the applicant did consular process, you can obtain the I-94 online. You need to attach evidence of relationship with a U visa principal. In Yuri's case, you will add a marriage certificate translation as if there are any prior divorces, you also need to attach that. You also need a statement from the applicant indicating when and she needs an extension. And this doesn't need to be a long declaration, just the reason, example, I came to the country a few years later or a year later because I got delayed for my consular process. I need to extend my status to apply for the green card, and I need to comply with 3 years of continual physical presence in the country. And remember, the I-539 by itself, it doesn't extend the authorization to work in the country. So if you have a derivative that is already driving or working, you also need to file an I-765 employment authorization package using the code as in the U visa, A20. And you can also request fee waiver if needed for the I-539.
Cecilia, we're not seeing any problems with extensions. Cecilia and I have been answering some questions about the interplay of the adjustment for principal and extensions. I have not seen problems getting them eventually. I mean, the problem is getting them to act on them, but I've not seen them deny them. Have you?
I have not, no.
Okay. Okay, so
no,
you can see...
to file before the expiration date, because if the client is working and they have, 3 months to process the employment authorization, so he may be out of I-765 status, so that may be an issue for him if he's working or her.
Yeah, but just a note on that there's no longer any 90-day turnaround time according to the updates in the regulations. But what they have said in terms of what that while there's no kind of post 90-day turnaround time, that folks who are renewing their work permits may do so up to 180 days prior to the expiration of their work authorization. And that if you don't hear anything after about 4 months, then it would be appropriate to reach out to the hotline. So that's just kind of a, not really relevant, but just kind of a practice pointer. Right, let's move on.
Maybe we should ask Claire's question now, as long as we're doing extensions. Oh, this is going to move, right? Okay, yep. So while they're filling out, I'll just read this, Maria, so I can then ask a question. So you all fill out this hypo, okay? Yuri filled out a status because the notario told him he didn't have to apply. What are his options now? To block 929, his spouse is ready to adjust. 539 nunc pro tunc. For those of you who don't know, that means getting them to put back the date to when it expired, other, and no vote. So Claire asked for an extension. Any suggestion on how to resolve an issue for a derivative who doesn't seem to have received an I-194 when admitted to the U.S. via an airport point of entry? They can't get an I-94 and they try on the electronic site. Would filing a 539 with evidence of the admission because of the stamp in the passport meet the requirement presence in the U.S.? And now you're talking about requirement for purposes of adjustment, right? Okay.
Yeah, I think it will be, number one, check online the names, the spelling. Sometimes Gonzalez with S or with C or with, makes a difference on the officer, and that may be an issue with the I-94 online. So check the spelling. Check the middle name, the last name, and also if no, yes, as in the past, copies of the passport with the stamp will be enough. And I think you should add a letter explaining that you can obtain online records.
But what about the 102? Aren't they filing those, the I-102s, to the replacement I-94s?
The I-94 now is online,
right?
So you don't get the stamp. You get an online stamp. So you get the stamp and then an online proof, but she cannot locate the online document.
Okay, and Ashley says she's actually used airline itineraries and other evidence for when they can't get the I-194.
Yeah, so that will be enough.
And again, this is the kind of thing where we can help out because it's generally a good argument that it's their own fault that they can't get the documents. It's like, I had no control over this. You didn't get it to them. So you should accept this other evidence, and we can help with that if it doesn't work when you make the arguments on your own.
All
okay,
right.
so we finish up the typo?
Sure.
Yeah.
Oh, whoa, where'd it go?
Oh, sorry, that's not what I meant by finish up.
So, yes, I think that I would agree with the 97.3% of you that says that you would file the 539 and ask for it to go back to the expiration date of his U visa. And then if it is at the 3-year period, then you could file maybe the 539 receipt notice with the adjustment of status if he does have the 3 years of continuous physical presence and see what they say. Gail, why wouldn't the 929 be an option?
Oh, you're asking me?
I am.
Okay, so the problem is I wasn't reading the hypo. I was answering questions, sorry.
Okay. While you're multitasking, the 929 wouldn't be an issue because Yuri already has U status. The 929 process is only for individuals, qualified family members who have never had U status. So that's why filing the 929 at this point really wouldn't help him out. So then I would file the 539 as a receipt notice. If he's adjustment eligible, then they file the 539 receipt notice together with the adjustment packet and see how it plays out.
But
so, and if people do anything differently, then let us know.
And for some of these cases we've been discussing with the adjustment and the extensions, and if someone can't perfect their U derivative status because they mom adjust, does that mean they can't file a 929, or do you think that would fit in the exception?
Nope. I think that they couldn't. I mean, I think if they had U status, then they have U status.
Right. But the filing of it doesn't preclude the 929. Okay, good. All right, so are we ready to move on to the next typo? All right.
I think that
we're taking this over, right?
Do we skip ahead? Yes, I think now we're going to the 539.
Well, if you have any questions about how to complete a form or what to put in some of the boxes, you email us and we help with that as well. And you always have in the USCIS website all the forms, the instructions. Check in there for edition date. The I-539 last edition is December 23, 2016. No prior edition accepted, so make sure to check the last edition. If you are running out of time, you don't want to get your case rejected. Also, it has the filing fee in there, and Vermont Immigration Service changes the fees often also.
Yes. Maria, we're having a hard time hearing you. You're basically saying you got to use the most recent version of the forms, right?
Yes, yes, because attorneys tend to have a pre-filed form, you know, and you use it, and you use it, and sometimes you get the case back because it's an obsolete form. So go online, check the form, check the date, and check the filing fee. You can request fee waiver, but check the filing fee. Okay. An extension cannot be granted to derivatives that are outside of the United States and never had EU visa status, as Cecilia was saying.
There's nothing for them to extend, so yeah.
Yeah. If you have questions about how to complete the form, let us know, please.
Yeah. Okay, so let's move on to the next slide, please. Are you doing this one, Cecilia?
Yeah, and I understand that, you know, we've been working with a lot of different hypos today, so I really appreciate everyone's patience and participation. I know it's, you know, 3 o'clock and our caffeine is wearing off, or it's maybe lunchtime if we're on the West Coast and we just want to get to lunch. So I appreciate everybody hanging in with us. So I'm going to thank you. Oh, my goodness, you read my mind. Thank you. Okay, so Anna has 2 kids. One's in the U.S. and the other one is in Honduras. Anna has a U visa, and when she filed, her son, who was in Honduras, Enrique, said, you know what, not really interested in coming to the United States. But last year, he changed his mind, and so they filed a 918A last November, and it's still pending. What do we do?
Oh.
Okay. There's more than 20 of y'all out there. There you go. Thank you. All right, I'm waiting to get at least to 50. If we can get 50 people, then we'll close the pool.
Ask for an intervention. You missed that.
Right. So
send an email to assistant, request an intervention.
Right. Why don't we say, to answer Jess's question, why don't we say Enrique is 15? If that changes your
How old did you say? 15?
15.
15? Okay.
15, 1-5. Okay. All right, why don't we close it up? So if Enrique is 15, right, then it might make sense to forgo the 918A option and then proceed with the 929 because Enrique is not going to have U visa status until he enters the country with U visa status. And so I think right now I would maybe say, you know what, Vermont, I'm not really interested in the 918A. We're going to file a 929 for Enrique to come in and as a qualified family member and adjust under 240 or in consular process under 245M. Now, if we can close the poll and then we can ask the question and people can put in their thoughts in the chat box. If Enrique were turning 21 in June, how would that change your assessment? Jess is like right out of the gate. I love it.
Yeah.
She would do the 918A, exactly. So you would have to file an extension for mom and proceed under the previously filed Sub A. And Jess or Yolanda, can you tell me why? Right. And so he won't get into the United States until he's about to turn 21, and there is no age-out protection. Thank you, Leah. There is no age-out protection for 929. So if Enrique is about to turn 21, then the 929 option is not going to help him. But Anna still needs to have her U visa status because once she adjusts, then the 918A option is cut off. So Anna needs to extend her U visa status until Enrique is able to consular process in with his own U status, and then you can adjust.
And this is a case where someone may need to explain to the consulate the VAWA 2013 age-out provision. Right?
Mm-hmm. Okay. And so again, it's often kind of important to map it out, right? And so this is what this kind of strategy does, kind of looking at the timeline of the cases. So Anna, we know, has October 2013 until this October, right? And for some reason we have Jose, maybe his status is a little bit different, but he can still eligible for his 3 years to consulate process. And then we have a process that was started, maybe last November because the sub-A wasn't filed concurrently with the underlying application, and how that kind of would affect the timeline. So this is just, I think, an instance where where there are all these multiple timelines to making sure that you're kind of aware of the entire picture of the family in the case.
And just because that you filed the derivative with the principal doesn't mean the time's going to be the same, because if the derivative has inadmissibility issues, they're likely to end up with different time frames because of the RFEs regarding those.
So now we're going to talk about acquiring derivatives after approval, and this is kind of in the U.S. So this is what we're looking for, that the inadmissibility grounds, again, you're looking at 212D14, and there is no inadmissibility issues when you're looking at cases like for under adjustment under 245M, and it's entirely discretion. And so I think it's really important to frame these arguments as if you were filing an I-192 and making the same arguments and the same kind of balancing of equities as you would if you were doing it at the U stage. And so that's why you're going to have to look at the criminal issues, look at the immigration issues, look at any inadmissibility issues. And you're going to have to look at them and argue them on why a favorable grant of discretion is warranted in these cases. And I think that, to Gail's point, making the argument why this person would make a neighbor. So if I were up in Essex, Vermont, would the adjudicator want to have, your client as their neighbor, and laying out all of those different issues on why this person, the grant, and why a grant of favorable discretion is warranted in these cases. All right, Gail?
Sorry, I had to unmute myself. Okay, so a quick identification of some U adjustment issues we're seeing, and what we suggest you do about them, and then we'll open it up for further Q&A on anything you want to talk about. The two issues that we see RFEs on primarily are what you're using to document the necessary continuous presence for adjustments, and there are two kinds of issues there. One is if you've broken the continuous presence, and then what you're actually using to show continuous presence. And although there's nothing, I think, based in the law that says you have to show something from every month. I think the more thorough you can be and the more varied kinds of proof you can provide, the better. However, this is one of those areas where I would suggest not killing yourself getting the stuff and seeing if they come back with an RFE, because part of what we do is try to hold them accountable for applying a higher evidentiary standard than Congress applied. As you know, Congress created the most flexible evidentiary standard for all these cases, the any credible evidence standard. And what we see is kind of a general approach at Vermont is to apply the primary evidence standard, because that's what all their adjudicators have been trained on in other forms of applications. And so we do a lot of pushback saying what you're really asking for here is primary evidence, and that violates the law. Having said that, let me give you my little lecture on what any credible evidence means, which is, remember, it's about credibility. So from their perspective, you have to present the best evidence, which, again, in their perspective, is the primary evidence. But if you can't get that, then you explain how you tried to get it and why you couldn't get it, and that's what supports the credibility of whatever evidence it is you are supplying. I actually wrote this up because I was writing it down so often in technical assistance, but I turned it into a little advisory you can find on our website. And the other thing to note is just if your client ends up breaking continuous presence, if either of their own accord, because they didn't tell you they'd left and you didn't find out until after it was already broken, or because they couldn't get processed back in. We have seen Vermont agree, without saying so, frankly, that you could reaccrue the 3 years after you entered again. We helped, some of our members wrote a brief. They submitted it in response to it, an intent to deny, and they got granted without them, Vermont, saying why they granted, but we assume it was based on the argument. So we haven't gotten them to agree either orally or in writing that this is true, but we think we're right on the law on that. So, okay, so let's move on to the next slide, please. The medical examination requirement, again, is not in the statute, and we argued with them for the first 2 years about why they were requiring it, and basically we couldn't get them to back off, and it frankly isn't the highest priority for us in terms of policy advocacy. But in general, you probably want to wait to file it until it's more recent, because it's going to take so long for them to even open the file that you might as well wait for them to send you an RFE saying, you're missing a medical exam, and then at least the medical exam that you file will be fairly recent for them. If you really can't do it, then let us know, because we think they're wrong on the law on this. But it's just CIS is, it's a bureaucracy, so they're used to doing things a certain way, and so they take the procedures from other areas of the law and glom them onto the UVs and VAWA processes, and we only fight back when it really creates a problem for your clients, and this is one of those examples. Here are some. So to me, the big problem with 929s, and if you're contacting me with a question with a case, the big question I would ask for you is, so is the person who's considering doing a 929, does he or she have any inadmissibility issues? Because as you probably know, at the adjustment phase, you cannot waive inadmissibility. It all goes into that general discretion pot. And what we have seen is they view themselves as essentially having completely unfettered discretion, which makes it very hard to win discretion arguments. The one place where the Administrative Appeals Office will actually review those cases, on the other hand, is with adjustment discretion. So if that's really your only option, or you have a principal who doesn't want to wait around another 4 years before they can adjust, you could frame the inadmissibility issues in the discretion context, really ramp up your positive equities for discretion, and then we can see if there's a way to challenge it if they deny it at the AAO. We talked about the continued presence. The failure to comply with LEO requests isn't just for these after-acquired 929 folks. It's this general practice pointer is useful for everybody. Specifically, this is designed for people who obviously will never have been asked by law enforcement to do anything, which is going to be true with all of your derivatives. They're not actually the ones who have to provide the help for law enforcement. So if they're asking for it, you just say, we weren't asked. We would help if they asked, but it's paid. But the other thing we would ask you to do is say that's not required by the statute, because we do think this is another place where they are basically reversing our interpretation of the statute and putting the burden on you and your clients to show that you've continued to be helpful, when we think what the statute actually says is they have to show that they weren't helpful. They didn't provide ongoing help. So we did push back on that when the regulations came out, and they said, okay, fine. Then you don't actually have to get another certification. Just give us some statement about whether they've asked you for more help, or if they have asked you for more help, what you've done, or show us that the case is closed. So this is another one of those areas where I would say don't kill yourself getting another certification at the adjustment phase. Just once you start a case, in your case file, keep notes about when you have contacted law enforcement, when law enforcement contacted you, put any documents that show a case is closed, so that you can easily write up a short summary of any further contact with law enforcement or no need to continue contact with law enforcement. Another problem with the 929s is, remember we talked about how an approved derivative U basically becomes an independent U holder. That is not true for 929s. That's more like the regular family-based system where they're attached in terms of relationship to the principal. And the big hardship thing you have to show is family unity, which in general is not going to be a problem. What we find, however, is that the most persuasive arguments come from your principal and not from your person abroad. So I think the best argument you can make is, I'm the crime survivor. I really need my kids here or my husband here to help provide the support I need and to start living my life again the way I need to live now that I'm away from my abuser or my perpetrator, or I'm dealing with the consequences of being a survivor of crime. We find that those may also, going back to the inadmissibility problems for derivatives, those often can be your better arguments, for instance, with the way too common problem of juvenile derivatives with multiple DUIs, frankly. And if you have those cases, you should contact us, because those are the few cases where I don't see them ever granting today. And we'd love to, if you do, we'd love to hear it, but those are really hard cases. Okay, so I think that covers us. Let's move to the last slide. I think it's the last slide. Up next, we're doing applied derivatives. Right, Maria, you were going to tell them about the forms for this, right?
Yeah, this is the consular process for I-929 applicants. Remember that you will be coming in as an immigrant. So you would apply for an immigrant visa with the Department of State, the consular section. You will need Form C-28, the DS-260 that replaced the DS-230 that was the paper copy. The 260 is the electronic version. We have copies of this in Spanish if you want to complete ahead of time with your client. The Form DS-2001, which is the form that you will notify the U.S. Embassy or consulate that you list in the cover letter that you are ready for an interview. Remember to have all original documents or certified copies that are listed in the instructions for immigrants visa applications. You don't need Form I-864. You do need the I-864W, signed and completed for all applicants, for all derivatives, one for each. And you need the I-693 medical form using one of the designated clinics from USCIS. The cost as of today is $379 for the immigrant visa. There are no waivers. You cannot request fee waiver for this fee. You have to pay. And one more thing. So you will be notified by the National Visa Center. They will contact you and they will schedule the appointment. Once your client goes to the appointment, he will get a visa, an immigrant visa. He must travel, he must come in the United States before the expiration date of the visa. Make sure to check also passport, that he has a current or she has a current passport before the interview, please. The passport will be stamped by the officer, by the Control and Border Protection Officer upon entry to the United States. That is the day that is the admission as a legal permanent resident in the country. And the
so backing up
Yes.
Backing up a second on the forms to file, this is a question from the audience. If you had filed a D-28 with a 929, do you need to file another one with the DS-260 and all of that?
Which form?
The G-28, your representation form.
Well, in that part, you have another form that is called 261, that is an online choice of address and agent. You are doing the consular process now. Yes, you need.
So you need to file a G-28 basically every time you file anything, it sounds like.
Yes. Okay. And remember, this is for each derivative. Yes.
Right.
And so your client comes in, he will get a stamp on the passport. That's the date of admission in the United States as a legal permanent resident. He has to pay a new fee of $165. That's the new fee. That if you do not pay that fee, he will not get the card itself. The card will be made once he is in the United States. If you have questions, this is the online form. See, you have the DS-261 online choice of address and agent. That's the online form. If not, you use the G-28. There are also some emails in here if you need to have questions. If you click the links, you will have the email. And the next one is the form DS-2001. That is mainly the form that you are saying my client is ready for an interview. And it says that you need to have all original documents or certified copies ready for the interview. And super important, if you have kids, minor kids going to the interview, remember that they will not be allowed to go by themselves. So you may need some power of attorney or a guardianship, and that person needs to have an ID to get in the consular section of the U.S. Embassy.
Okay, so what we're going to do, what little time we have left, any questions you have, why don't we put on the last slide that has the contact information while we do that?
Yes.
And one thing that's important here is this bottom on that relates to the consular processing is this ICWIClaw.org. They have a really useful interactive database that tells you what happens at each consulate, who your allies are there, how to contact them, what they're asking for. Because unfortunately, we don't have the same kind of quality control system going with the Department of State that we do with Citizenship and Immigration Services. And so if we go ahead and put, we have 3 minutes left. We could answer maybe 1 or 2 questions, but meanwhile, you have that email there. That's what we're here for, is to help you with any questions about anything. Nothing is too stupid or too complicated for us to answer. So please send us, any questions you have. Any final thoughts from you, Cecilia or Maria?
Yeah, remember that we will be doing new webinars.
Oh, yes.
Your input on new topics.
Yeah, let me address that. I forgot. Thank you. So yeah, we're going to have finished off with our April webinar, the original 6 webinars we proposed to OVW, but we would like to propose another series to them before our grant closes out next year. So send us any thoughts you have on topics that would be useful. Let us know if you like the interactive, you prefer more of a talking heads or, kind of format. We can do anything from interactive on basics to interactive on really advanced, complicated U-Visa issues. There's something in between. So we would love to hear your thoughts on that. And someone's asking about the recording, Patricia. Do you want to share with people how they can get the recording?
Yes. Patricia is super good. As soon as we finish the webinar, about an hour later, she sent me the closed captioning and the recording, and I send and the participant list, and I will send out all that to the participants, including the chat and the closed captioning.
Okay, and then Kathleen has a basically what forms to file question for 929 for consular processing. So Kathleen, why don't you send that, and you can have this conversation back and forth with Maria, and she can help you out. Maria is really great at helping you figure out what forms to file, because she does a lot of that. And let's see, we have 1 minute. So Yolanda's question is, if you're filing for a U adjustment within 8 or 9 months of the U expiration, when and how do you request an extension of the work authorization? Is it a request for an extension of the U work authorization or a request for adjustment based on, a C9 adjustment-based work authorization? That's a good question. Do we know the answer to that? Adelia, what would you say?
Well, when you file for the adjustment of status, you file the I-765 under 12C9.
Right, but the question is you haven't gotten any action on it yet, right? So if you haven't heard back from your U adjustment application and it's going to expire, should you also do an extension of your regular work authorization?
I think it depends, right? I think you can either do C9 or you can do, or your A19 if you're the principal. Once you have filed for adjustment of status, your U visa is continued until the adjudication of that adjustment. And so I think that you could potentially have 2 bases at that time. And so, yeah, Kathleen, if you C9 without a problem, and I think that makes total sense.
And just a footnote, remember to do that for your avalas who are immediately eligible to adjust.
Yeah.
Okay, I think it's 3:30. I think we need to shut it down. But so definitely, if the rest of you have questions, send them to us. That's what we're here for. And we're sorry we can't stay on to.
And one more thing, all recordings are also on the TA to TA calendar or library if you need to access them.
Okay. And so, Yolanda, just send us an email, and we'll finish this conversation with you later. Thanks to everybody for being on here, and thank you very much to
Thank you.
Appreciate that for helping yourself.